I mean, I just tell people I'm an engineer with a law degree as opposed to an attorney, joking around. But yeah, I mean, and the other thing is like software. Everyone wants to patent an app, but you can't patent software.
Did I just hear you say you can't patent software?
Not in the US. I mean, there's some software that you can. It's very narrow and it's very expensive because you got to argue with the office. But most software inside the United States is unpatentable. There was this decision called the Alice decision about 20 years ago or so. And it basically just said that software is nothing but ones and zeros, hence, it's an abstract idea. And the way I like to explain it to people is I don't know if you ever saw the movie Rain Man. Guy was brilliant, right? Autistic, could figure stuff out. If there's any possible way that someone could do the process that the software does in their head, you can't get a patent on it. So if you take in information, you process it, compare it to knowledge, and then spit out a result, you can't get a patent. Generally.
Interesting.
There's always caveats. Let me preface that.
Welcome to the Iferia TechCast. We'll bring you all things science, engineering, technology, and innovation. Today, I'm excited to have Austin Bonderer, a patent attorney with a fascinating background in civil engineering and intellectual property law. With over 25 years of experience and his name on 700 plus US patents, Austin brings a unique perspective from his early days as a US patent examiner to leading nanotechnology patent prosecution at a global Fortune 100 company. His work spans medical devices, valves, and cutting-edge technology. He's passionate about helping engineers protect their inventions. So, Austin, thank you for joining us.
Thank you for having me.
Yeah, so is there anything you want to add to the intro, or you think I did enough justice to it?
I think you did great justice. I mean, I just tell people I'm an engineer with a law degree as opposed to an attorney, joking around. But yeah, I mean, yeah. So
All right, so we dive in. So, Austin, you started as a civil engineer. So, what moments made you pivot to patent law?
okay. Actually, it was kind of when I was a kid. My dad's house almost burnt down, and then during that summer, and I grew up in Mississippi where it's pretty hot. So in the summertime, I was in the attic wiring his new smoke detection system. And I was like, there has to be an easier way. So I developed a wireless smoke detection system, built one out of two smoke detectors. And remember those old wireless doorbells? You're probably too young to know about these. But anyway, I put them together. And the idea was that, instead of having to wire it, you could have them wirelessly relay through the entire house. So that's what I wrote my senior cornerstone thesis project on at Virginia, or for engineering school. And that's when I got interested in working at the technology transfer office at the University of Virginia. And then I started working at the patent office after that.
Great, that's quite a fascinating journey. Yeah, so give us just a perspective of what exactly like the patent industry looked like back then when you made your smoke detection project, when you tried to patent that project.
Oh, oh, well, I did it myself and it was horrible. And, the application was bad. And, that was part of my project because I never, it's something that you've never done. You can write a term paper explaining what it is, but it is a little bit different to write a patent application. And so my patent application didn't go anywhere. Two, the other problem is I went to go work for the patent office and they kind of have a prohibition against examiners filing patent applications. It's because, there might be inside pool, you might know the person. So they kind of discouraged me from moving forward with that. Had I moved forward with it, I think I would have made a lot of money. But, I'm here now and I'm happy doing what I'm doing. So
Interesting. So, Austin, does your engineering degree give you any edge when evaluating technical patents?
I mean, yes. I mean, there are certain things that you need to know when you work in patents, and especially mechanical type patents, or, you know, just technical things. You kind of just have to have that engineering mind or that scientific mind in order to argue with the patent examiner about, why this feature wouldn't work, with the way that they're trying to say it would work and those kind of things. Obviously, civil engineering is not in my day to day, but your basic engineering, math, physics, mechanics, those kind of things you would
Yeah,
use every day. Yeah, in your practice.
yeah. Okay, so say I'm an engineer who just invented an innovative product. How do I determine if my invention is patentable?
Ooh, okay. So that's the question I get all the time. How do I know if I might have a patent or something to patent or not? I always say, did you solve a problem? And
Okay.
solving problems is what inventions really are. They're just solutions to problems. Either you found a great problem that no one knew about and then you came up with a way to solve it, and that can be a path, or you solved a problem that people have been working on forever and you were the first one to it. So that's when I tell people that that's when you might want to reach out to a patent attorney or someone to see if you might have something value at that point.
Interesting. So, what are the common mistakes you see technical founders make for when filing for patents?
Well, I can tell you the biggest mistake that most people make is disclosure. You know, we're pretty excited about if we solve a problem, right? We're like, look how cool this is. And you want to tell
Yeah,
exactly your other engineering friends. Yeah.
yeah.
You're like, look at it. It's my baby. Here it is. I'm going to put it on Facebook and you're going to see it. And, that kills patents. You do not want to disclose it. You want to loose lips, sink ships. You want to keep it quiet. So that's what I tell everyone is like, look, I know you're excited. And if you have to tell someone, tell a patent attorney, but don't tell your friends. Don't tell all these other people. So, yeah.
Interesting. So, you worked as a lead prosecutor at a global nanotechnology company, Foscon. So, tell us about your time leading nanotechnology patents at Foscon. So, I'd like to know what separated good patents from great patents.
That is so hard. I mean, in all honesty, like you know, you could have the perfect patent application, but if the technology underneath it is not worth anything, then that's not a really good patent, right? Then you could have a horrible patent application, but the technology is so great and it covers it just enough that that could be a super valuable patent. So, it's one of these things. People always ask, "What's your success rate?" And I'm like, "I'm pretty good. I mean, I have a high success rate. I've obviously, like I said, over 700 patents have my name on. So clearly, I've seen a lot and I can move things along and I can let you know, hey, we're not going to be able to move this along. You know, I'll give you my honest advice. But it's the underlying technology that makes the patent valuable or not, right?
Yeah. So, has there ever been any case where you see a technology that is so good and innovative, but the person in charge maybe filed for patent application in the wrong way, and it ended up affecting whether or not they got approved?
Yes, that happens a lot. And the big problem is that say inventors, they don't go through an attorney and they want to write their first provisional application. So they're like, hey, I filed a provisional. Can you file the non provisional for me? And I'm like, sure. But probably the problem is we're stuck with the verbiage of the provisional application because it's still part of the file. So it's really hard to go back in there and fix things because when you're drafting patent applications, you really need to like my theory is you disclose generic, very broad, then to very specific. So, very simple example, a fastener, and then you say where in the fastener could be a screw or a nail or something like that. But you get to use that broad term fastener first. And a lot of times people who are so invested in their application and their invention, they're so specific. And they're like, it's got to be this steel. And I'm like, no, it can be any metal because we all know that people will spend money on cheaper, worse alternatives. So don't be so specific. And that's the issue with inventors. They're like, it's got to be this steel, it's got to be this, and it's got to be that. And I'm like, it doesn't have to be to work great. It does, but people will make inferior products and sell them cheaper if you restrict yourself too much in your patent.
All right. So, You talked about provisional and non-provisional patent application. Could you break that down for us and like explain it so that the normal average Joe inventor who has no idea what patent is about or how to file patent applications get to understand what these things mean?
Yeah, I almost wish they never came out with the provisional patent. What it is basically you file an application and then it gives you a year to file non-provisional. So it's basically kind of like a patent pending, but it'll never become a true patent application unless you file for that patent application as a non-provisional. And what happened was, as soon as that came out, all these companies out there, and you've seen them on TV probably, like, oh, we'll file you a patent for $500, blah, 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 all this other kind of stuff. But guess what? It's not worth it. It's not good. Your provisional needs to be as detailed as your non provisional because it's all about filing dates and it's all about putting stuff before the office. So if your invention really requires 17 pages of disclosure, and these companies are like, hey, we'll put 3 pages down. We'll write you 3 pages. You can file it yourself, all this other kind of stuff. You're missing out on 14 pages of disclosure that might be very important to your idea, but you feel safe because you're like, hey, I have a patent pending, but you don't have a full patent pending. You have, less than a third of a patent pending. So the provisional came about because there was this weird quirk in US law. And basically what it was that when say that you lived in Japan and you were a Japanese inventor, when you filed in Japan, you got an extra year to file in the United States. And then you would get the full term of the US patent. And therefore, the Japanese inventor would have 21 years of coverage, where the US inventor would only have 20. So they came up with a provisional just as a means to rectify that one situation. It is not a cheap patent. It is not an easy patent. It's not one of these things that should be relied on just kind of to get something to the office. Now, I understand that some situations require that, but it can end up getting you in a lot of trouble. And I've seen it happen.
So, does it mean that everyone like compulsorily have to first of all file a provisional patent application, then wait a year before filing a non-provisional?
Correct. So it's a placeholder for you to file a non provisional. And they can have some use. Say that you know that you're going to develop more say you're going to develop more, like you have a base idea and you know that during that year you're going to work on this idea, you'll probably come up with some other features that you want to get covered. The provisional process allows you to file as many provisionals as you want, and once you file them and that year is up, you can include all that information in your non-provisional, so you get all those different filing dates for all the advancements that you made for those specific parts.
Okay,
And just to be clear, the non-provisional is what people consider the traditional application.
so say I discovered something or I solved a particular problem and then went to file for a provisional patent. And during the course of that 1 year where I have to wait before I can file for a non-provisional patent, another person solves the same problem or discovers the same invention, and then that person goes to file a provisional patent application too, just like I did. Does it mean that the two of us can then file for non-provisional patent application after the course of that 1 year? So the question actually is, can two persons have patents to the same solution or like the same solution to a problem?
Well, your provisional, a filing is a filing, and the first one to file wins. So even if you were provisional status, they came after you and they filed non-provisional, you would still win as long as you filed a non-provisional. So it's all about filing dates with the USPTO.
So does it mean that if I file first, I'm the only person that will be able to file a non-provisional? Is
Well,
that
they'll
what you're
be able
saying?
to file because, technically no one really knows. It'll just be more of an issue of who actually has the valid patent.
Okay, so is there a legal way to then agree on who has a valid patent when people, I mean, the two parties then discover that they have patents for the same innovation or the same solution to the problem?
They used to have this stuff called interference hearings, and they just got so complicated. They just said, no, we're not doing this anymore.
Hmm.
So they just turned to a first to file system. The first one to the patent office wins every time.
Okay. All right. So, from what I've understand so far, you first of all have to file a provisional patent, then wait a year, and then file a non-provisional.
You technically don't have to wait a year. You can file it literally the next day.
Wow.
It just gives you a
So
year. It gives you a year, but you can file the next day.
if I can file the next day, so what's that 1 year there for? What exactly do I need to wait a year for?
Well, you don't have to. Some people want to do it because, like I said, I only use provisional patent practice generally in two situations. And one of them is that the inventor is continually working on this project. They are going to invent more items that go with this patent. So we can actually, you have the provisional, which covers A plus B. And then all of a sudden, it took you a while, but you came up with A plus B plus C, and you want to include that in your application. You can include that in your non-provisional. But once you file your non-provisional, everything is set in stone. You cannot add what we call new matter to your application.
Yeah, thank you for that. It makes more sense now. Yeah, so I like to ask, how should engineers and inventors properly document their work so that it supports like future patent applications?
Well, I mean, back in the day when we had interference and it was the first to invent system, we would say, hey, we need your documents to prove that you invented this on these dates. Now it's just what is disclosed when it gets to the office. They don't care about when you came up with it, what you did. I mean, they care if you've disclosed it publicly, but otherwise, you know, just, get your invention to a patent application. I mean, explain it to the patent attorney, they'll write it up and they'll send it on its way. But, we don't really concern ourselves too much anymore with documentation because we don't have to prove, well, we can't prove, there's no point in proving first to invent anymore. The only possible issue where that would come up is if someone stole the invention from you. So, if the guy down the street somehow, came up with the same invention you did, and you're like, you weren't even working on that, but somehow you saw my stuff, but now you're filing a patent application. That's when that documentation would be helpful.
Okay. So say maybe I have a solution or something I want to patent, but then in the past I had discussed it with my friend or somebody that I'm close to, and that person sneakily goes to take that idea and patent it before me, before I could find out. And I then later found out about it. So how do I take legal actions to make sure that my work like comes to my name, like the patent comes to my name?
Right. So that's called derivation. That's the one thing where you can say, hey, I actually invented this first, and they try to pick a patent on or take a patent on it. You can just, regular court case, you just go through it. I'm sure it's difficult and expensive. But if you can prove derivation, they will remove them as the inventor and put you on it because technically they had to lie to the patent office. What it is that when you file a patent application, you have to sign an oath or declaration that you believe you're the first and true inventor of this item. And if you know that you took it from someone, that's perjury.
Okay, yeah, that's very much understandable. So I like to ask, Austin, what emerging tech fields are you seeing the most patent activities in right now?
Okay. I have to tell you, like, what I get calls from like independent inventors almost always is pets and babies. I think they just spend so much time taking care of, their pets and their babies that they come up with new ways of doing so. And so they're always thinking about there's got to be an easier way of doing this. And so, you know, I get calls on that a lot. And the other thing is like software. Everyone wants to patent an app, but you can't patent software.
Excuse me, did I just hear you say you can't patent software?
Not in the US. I mean,
Wow.
there's some software that you can, it's very narrow and it's very expensive because you got to argue with the office. But most software inside the United States is unpatentable. There was this decision called the Alice decision about 20 years ago or so. And it basically just said that software is nothing but ones and zeros. Hence, it's an abstract idea. And the way I like to explain it to people is takes, I don't know if you ever saw the movie Rain Man. Guy was brilliant, right? Autistic, could figure stuff out. If there's any possible way that someone could do the process that the software does in their head, you can't get a patent on it. So if you take in information, you process it, compare it to knowledge, and then spit out a result, you can't get a patent generally.
Interesting.
There's all caveats. Let me preface that. But for the most part, software patents are dead. And even when we could get people's software patents, it would take like 5 years. And software moves so much faster than that we would go to our clients and say, "Hey, we got you your software patent." And they'd be like, "Thanks, but we stopped doing that 3 years ago."
Interesting. So, for big companies, big tech companies with software that people use globally, like let's use like the likes of Instagram, Facebook, or WhatsApp, for example, do those guys actually patent their software? Can any average Joe just take AI tools and rebuild Facebook and everything will be cool?
Well, I can only speak for the US. And so basically, it's now the Wild West. No one really has patents on software, which kind of helps people making software is that you're not stepping on anyone's, you know, patents, but Europe may, I haven't researched this, so please don't hold it to me. I think they still allow software patents. So you might make software in the US, but you're still going to have the issue when you bring it over to the EU.
That's interesting to know. So, how can engineers with limited resources or limited budgets strategically protect their intellectual property?
I mean, that's tough. You got to hustle, I guess. You got to get it. You got to either bootstrap it yourself, try to find investors. If you're finding investors, you need to make sure you use NDA practice. Basically, anyone you disclose it to, you have them sign an NDA that says they're never going to tell anybody. And the reason that they're, talking with you is that they want to try to enter business with you, or they might want to enter business with you. So that's pretty much what you really got to do is you got to bootstrap it. Unfortunately, it's not cheap. It's expensive. Was talking to a possible client today, and on the high end, you're generally looking at a minimum of 10 grand to get a patent.
Oh, wow, that's
Yeah.
huge. Like every single patent, including those one on pets and babies you talked about. Do I require that much?
Yeah. I mean, well, some are less than, obviously it spans the gambit, but I mean, generally when okay, I can rephrase it. There are some that cost less. I mean, if it's a very simple idea, then it doesn't take as long to write it. That will decrease the cost. This is why I don't use fixed fees myself. Some people do. So when a simple invention comes in, I charge them less. When a complicated one comes in, I charge them more. But and it's only because of the amount of time that it takes me. Some people charge fixed fees, and what they do is they charge you the same for the simple and the same for the complicated, and they hope it all comes out. My suggestion is go with someone with hourly rates. But yes, some very simple ones will cost you less, but you are talking I mean, a minimum to get a patent application filed with the USPTO drawings and everything, you're probably looking at a bare minimum 4 grand. And then you got to
Wow.
argue with the patent office when you come back. So they're generally going to reject it. We used to joke they're not the patent office, they're the rejection office. That's kind of you know, what they do.
Hilarious.
Yeah, exactly. So, and the other part is that while there's one patent office, you're actually dealing with 9,000, I think it is up now too. It might even be more than that because each patent examiner is really their own little patent. So you're dealing with that. They're going to reject you depending on the rejection. It's kind of like game theory at that point. So they do something, they use some art, then we have to decide how we're going to respond. Are we going to just argue? Or are we going to try to make compromises? How much do we want to compromise? So those are the kind of things that, influence the budget when we're dealing with this. I guess kind of the, part of it is that it's spread out. So once you pay the upfront cost of preparing and filing an application, you typically wait 2 to 3 years before you hear back from the patent office. So it's not all at once, but it is expensive. And this is why, like, when people call my office, the first thing I tell them is, look, you don't need a patent to make money. Look around. You see all kinds of things that don't have patents on them, and people are making money off of it. If it's a good idea, it's going to sell. A patent helps in the fact that it's kind of like insurance for your investment of time and energy getting this thing to market, but you can still make money even if you don't have a patent. The other thing I say is a patent in and of itself will not make you money generally. It's not very often that you can approach a big company and say, hey, look at my patent. You pay me to use my idea. Generally, they're going to want to try to design around it, or they just don't want to deal with it. It happens sometimes. I'm not saying every time. And then, the other thing I say is, look, if you don't have a business plan to get your idea to market, you're just going to have a very expensive piece of paper sitting on your desk.
That's a great perspective you put it. I mean, and the fact that you actually don't need patents to make money. That's
I'm
a
a patent
really,
attorney,
I
right?
mean, it's an interesting concept. Yeah. All right, Austin. So, if an inventor suspects that their patent was infringed, what's the first step to take?
If you feel like your patent's been infringed, talk to a patent attorney first, because understand that the claims define the invention. So when you have a patent application, you have an abstract, drawings, specification, and claims. The claims define the invention. Just like you have a land claim, you have a patent claim, and the claim defines the invention. So think of it kind of like a list of items that must be present in order for someone to infringe. A lot of times people are like, well, that's my idea. I know it's my idea. And generally, it kind of is the same idea, but the claims are very specific. And if it doesn't read on the claims, if it doesn't check every element on that claim, they're not infringing. So, oftentimes clients come up to me and is like, they're infringing. You got to check this out. And I'm like, this is why they're not infringing, because in the claims we wrote this and this. And it's kind of hard because when you think of patent protection, don't think of it like a wall. Think of it like a minefield. Okay. People can get through minefields. It's just how hard and how expensive is it going to be? Two, when we're trying to build defenses around your idea, when we're writing this patent application, we have no idea where the enemy is coming from, right? We don't know which way they're coming to approach us. So we're trying to, guess. So we put mines over here, mines over here, but there are smart people on both sides. So once your patent issues, your claims are set. So they're going to look at those claims and try to design around it so that they can practice the heart of your invention, compete with you, and then try to make money off the market that you created. Now, there is an insurance policy that you can use to try to help with this, and it's called continuation practice.
Can you like share a bit of insight on this continuation practice you just mentioned?
Right. So if you file a patent application and it issues without any children, which are called continuations. So it's basically kind of like one of these things where you file your first patent application, say it's going to issue, you can file a continuation, which is basically the exact same application. The only difference are claims. The claims are different, but the scope of the claim still must be found in the original disclosure. So we submit new claims. And then but if we know a competitor and we know what they're doing, then we try to design the claims to catch them in that. So it's a lot easier knowing what you're trying to get to step on your minefield than just speculating in the future what may or may not come, because they might find some other way around it. So you hope that you can draft some claims that would catch the competitor and still be considered to be within the scope of the original disclosure. I mean, continuation practice covers a lot of things. It doesn't cover everything. So it still has to be within the scope of the original disclosure. And that's kind of the limiting factor in that practice.
Yeah. So finally, Austin, I normally like to keep this one for the last. Okay, consider it an unrelated question, but one that I like to ask every guest. before we conclude the session. So, Austin, I'd like to ask, what does innovation mean to you? And what do you think innovation will look like in your field?
Well, I mean, right now, I mean, I assume everyone you talk to, it's AI. We're having a big kind of back and forth with that right now because I personally feel, and I know you have some closed off LLMs, but a lot of clients I talk to are like, yeah, I used AI to go search my idea or, come up with my idea and all stuff. I'm like, you just disclose your idea to the largest database in the world. That may be disclosure. Now, the courts haven't
Okay.
decided what is what, what we're doing here, but I'm not using AI with my client stuff until a court tells me I can't. And even then, sometimes it's kind of tough because I actually do. I've had to rework other people's work before. Sometimes it's just a lot faster for me to do it. And I've asked AI general questions here and there, and I can tell you I've found some mistakes. So we'll see.
Great. Finally, where can our audience get to connect with you and ask questions about patents and how to file for patent applications?
Well, they can look up my name, Austin Bonderer, and that's Bonderer. And as far as I can tell, I believe I'm the only US patent attorney with that last name. So all you do is look up
Interesting.
Bonderer and patents. And then people ask me, where did that ER come from? I'm like, my understanding is that my family and Roger Federer's family are from the same parts of Switzerland. And supposedly they throw on another ER if you had one. So, look up the ER and then patents, and you should be able to find me.
Great. It was nice having you here today. Thank you for showing up.
Thank you for having me. It's been a great time, and I'll do it anytime you need.